Before that, I should make you clear that presently judiciary is passing through a phase of crisis of credibility. This crisis of credibility was existing against the lower judiciary in the past, because there was huge corruption in administration in the past, and we have history of the culprits, criminals not getting punished and getting bail or getting the acquitted from the court, and allegations have been made from different quarters that judiciary has been involved in this process. So judges have been accused, but till now no judges have been removed due to corruption or some other negligence fault, and this shows the lack of accountability existing in the system. So one aspect of judiciary is that there is a crisis of credibility. Earlier against lower judiciary, now it is against the topmost judiciary. That means against even Supreme Courts and High Courts. And this takes place because of several reasons. One of the most important reason, most significant reason has been the seen judicial biasness. So judiciary has shown prejudices and bias in favor of some against some other. That cannot be made thoroughly clear that on which point judiciary is biased or prejudiced, because it is all about public perception and public expositions or public comment, and that is flooded in the social media these days. These issues are available in the social medias. You as a aspirant of civil service, you are not required to be much controversial against judiciary, or you should not talk much about judicial negativities. You should have a very balanced view regarding this as a civil servant. So as an aspirant of UPSC also, you have to be very balanced in matters of writing about judiciary. Yeah, definitely you should have some criticism when criticism is due. You can quote some judges regarding the criticism of judiciary itself, and you should always defend the judiciary. You should not outrightly say judiciary is whole judicial system is corrupt. There may be 1-2 judges corruption is possible, but you cannot brand judicial system to be corrupt. It is significance of India, it's advantage of India, that Indian judiciary is till now the well protected and neutral. No institution targets judiciary directly, either legislature or executive, or even the mainstream media, that also does not target judiciary so aggressively. So you should keep in mind when you are talking or writing about judicial system in the country, you should not be so critic. So vehement criticism should not be there. You should have a balancing approach in this regard. Clear? Now, this concept of judicial activism, I will discuss to you from my broader understanding of the subject matter. That generally judicial activism is defined as the judicial intervention in the authority and power of other branches of government when that intervention is not due. So undue judicial intervention into the authority and power of other branches of government is judicial activism. Clear? So judiciary when tries to usurp usurp the power of legislature or executive or makes undue intervention in their affair. Judicial activism is said to exist. Write down. There has been separation of power. Legislature has their own domain of power. Executive has their own domain of power. And when judiciary starts participating in that process, this is activism. Like in 2023's question, 2023's paper, there was a question that now judiciary is actively associating itself in policy formulation. Or deciding policy decision, even mandating them. So when policy is mandated by judiciary, means they observe and see what in the policy should be executed, what in the policy should not be executed. Policy is not the judiciary's subject. Judiciary can just point out that which area policy should be framed by government. And legislature has to make law concerning that policy. Executive has to execute that policy. But judiciary is not just deciding what government should do, what government should not do. They are also deciding and mandating the policy. Got the point? So this is an area where judiciary has intervened, which is not judiciary's domain of authority. This can be called activism. Now, term activism has been used in both the senses, in a positive sense by some scholars, in negative sense by some people. So generally when you see the judiciary's view, whenever judiciary intervene, where judiciary has no authority to intervene or no power to intervene, or judiciary intervene into the authority and power structure of the government proactively, then judiciary or people belonging to the judiciary defend it. Judges generally have positive view of that activism, that it is failure of the executives, it is the negativity of the legislature, it is a indifference of these two bodies, then people suffer, judiciary has to intervene. Although we say judiciary is blind, like law is blind, judiciary says we can't be blind. We must observe, see cautiously, be sensitive regarding the problems of the people, any oppression against them. Or we should also see that society does not get victimized. The interests and rights of vulnerable downtrodden, backward should be protected. And if legislature are not taking right steps, if executives are not executing it properly, executing policy properly, law properly, or executives are not working properly, then judiciary must come forward and compel these bodies to perform. So judiciary takes charge of affairs of executive or legislature only when they find they are not completely functioning as expected, as desired in democracy. So one view regarding activism comes from judicial members, comes from judges, who always say that activism is good. Activism is in the interest of common man. Activism is in the interest of people. But if you see from the perspective of the legislature or executive, is that branch of government, generally this branch has confronted judiciary. Whenever judiciary tries to usurp some power authority of these two branches, they try to confront, they try to fight. Like in Keswanand Bharti case 1973, when Supreme Court came out with basic structure doctrine, then legislature tried to confront judiciary. In 1976, 42nd constitutional amendment was passed, and very big number of provisions of the constitution was altered, changed. Some scholar also called 42nd constitutional amendment as mini constitution. If you read article 368, the subpart 4 and 5, two provisions have been inserted in 368 by 42nd amendment, that parliament has no limitations whatsoever within the domain of amending power to amend any part of the constitution. Means article 368 was amended by 42nd constitutional amendment act to make it clear that the legislature can amend anything. And the same article, one subpart related to that whatever amendment made by parliament, it cannot be called in question in any court. So they amended to make clear that parliament has unlimited amending power. Even today, if you read article 368 4 and 5, subpart 4 and 5, you will find that the provisions are existing, that parliament has power to amend any part of the constitution, and judiciary cannot review them. It can't be questioned in any court of law. That means Keswanand Bharti's judgment was resented by the judiciary in by legislature in 1976. Same thing happened when Golaknath judgment in 1967 was given. Golaknath judgment was that fundamental right can't be amended, but that time legislature were right. So when this amendment was brought, this judicial order was brought, Golaknath vs. State of Punjab 1967. Then 4 years later, the parliament had brought 24th and 25th Constitutional Amendment Act. Out of which 24th is very important. It said that not only fundamental rights, parliament has amending power, so it can amend any part of the constitution. And rejecting this, Supreme Court had given its judgment 2 years later. 24th, 25th Amendment came in 1971. Resenting this, court came with judgment Keswanand Bharti 1973. Like judiciary and legislature confrontation going on. Several judicial pronouncements had been made, like very recent pronouncement relating to uh, there was an ordinance brought by union government concerning services in Delhi. So is services domain of union or it is state government's domain? Can amendment in the service related law be brought by union? And one ordinance by which LG of Delhi was given power to decide matters of services of Delhi, Supreme Court struck down that ordinance and given judgment in favor of the Delhi government. The legislature resented, government resented. They brought an amendment to the Delhi related law, and that amendment was passed in both the houses of parliament, recently by Rajya Sabha also. So collegium system also, attempt was made by judiciary to take to themselves the power of appointment, but parliament tried to resent it, executives tried to resent it. We see NJAC was brought. Why? It was resentment against the judiciary trying to take to themselves the power of appointment. But judiciary again aggressively works against it and makes that amendment concerning National Judicial Appointment Commission as null and void, unconstitutional. So judiciary's proactive approach has been resented by legislature, by executive. Therefore, they have a view that there is an activism, there is proactive approach, it is unnecessary intervention, it is undue intervention. We have seen that in UPA government, UPA 1, Somnath Chatterjee was speaker, and Supreme Court had given a verdict, that judgment, that in the FCI godowns, Manmohan Singh was the Prime Minister, FCI godowns, there is huge food grains being wasted, rottening, rats are destroying. Because of several reasons it is rottening. So why not? Supreme Court gives order that you distribute it among people. Then Somnath Chatterjee, who was from CPIM, he was a speaker of Lok Sabha at that time, he commented that judiciary should not unnecessarily enter into domain of policy. Even the then Prime Minister Manmohan Singh had said that it is executive who can decide that how food grains should be distributed. There should be a policy concerning that. So judiciary should remain within its domain. Means Speaker of Lok Sabha is commenting. One more speaker commented in matters of one intervention by court in Syed Sibte Razi was governor, and there was disqualification of one person from Jharkhand Assembly that time. So Somnath Chatterjee commented in that issue also, both issues he commented, and Prime Minister also resented. So this resentment shows that legislature or executives want to say that judiciary is trespassing. They are trying to entering without authority into the domain of power of the executives or legislature. Emergency is the best example of resentment of judicial activism. I will discuss about it. So there are two views when we talk about what is activism. Activism is something where judiciary is intervening into the domain of executive and legislature. And there are two views available or two sides available concerning judicial activism. So one view is a judicial activism is good. Second view, judicial activism is bad. One view is judicial activism is good, second is judicial activism is bad. And there is my understanding, knowledge of subject matter. Based on that, I am bringing one third view which has been taken by a very prominent Supreme Court judge. This view is there is nothing called activism. So now we have three views on this subject, three views on judicial activism. This view has been interpreted by, it has been said by our ex-CJI, Chief Justice of India, Justice P.N. Bhagwati. He can be called the father of PIL in India. So Justice P.N. Bhagwati is a father of PIL. He can be called father of PIL. So what is, this is very significant thing to understand as a student of public administration, as an aspirant of UPSC. You must understand P.N. Bhagwati's view is very important. What P.N. Bhagwati said. P.N. Bhagwati has given several lectures on this topic. And his approach led towards birth of PIL, public interest litigation. It's a very popular concept today and revolutionary also from the point of view of transforming the way judiciary behaves. So P.N. Bhagwati has given a series of arguments to prove that there is nothing called activism. Okay, so what he says, his arguments point I am writing here one by one. First of all, that India follows Anglo-Saxon system of jurisprudence. It follows Anglo-Saxon system of jurisprudence. In Anglo-Saxon system, judge in this tradition, judge is branded as neutral. Why judges are branded as neutral? Because if a judge is neutral, a neutral judge can impose can impose verdict. Only neutral judge. And only neutral judge people accept verdict. How he claims himself to be neutral? That I have not made this law, I am just interpreting this law. Like natural justice principle. I am not the maker of the law. I am just interpreting it. So I am finding the law. I am not making the law. So here judges claim, in this system judges can claim I am not making law. I have not made a law. I have just found it. I have just found it. Found it means searched that provision of the law. So I'm not making law, I'm just finding it. That means I'm picking from the law book and delivering my judgment. And that is argument he gives to prove that I am neutral. If he is proved neutral, then he can say, yes, it is neutral judgment and you are punished. You don't have other option. It's a neutral judgment, then others also accept. He is not the person who made law. He is just taking course from what is written. Like when you visit a bank and some rule is applied to you, then bank staff says, no, it's not my written. That the work will be finished 3:30, system will shut down 3:30. It's not my rule. It is already made by someone else. I am just executing it. Then you cannot say anything to that person. Why? Because you have to go to the authorities to say he has just shut down the system, because system work is not taking place after that as a rule. The same thing, judges, neutral judges can claim this. That is why in Anglo-Saxon tradition, this view prevailed, that judge is not related to lawmaking. But his argument, P.N. Bhagwati's argument, he says, this approach is a photographic view of justice. It's a photographic view of jurisprudence. Photographic means which is static in nature. Something which is stable, static. Okay. And he comments a very sensitive thing he writes. He says, comments that it is the truth of the lie that judges do not make law. It's a very important, significant statement. It is the truth, means we know that judges do not make law. It is the truth that judges do not make law of the lie. It is truth of the lie. It is a lie. It is lie. We know it as truth. It is truth of the lie that judges do not make law. He says, in fact, the making of law is the most thrilling job of the judiciary. Making of law is the most thrilling job of the judiciary. Most thrilling function. How this making of law? So law, he says, let me add some pages here. He says, law remains in a skeleton form. So law is not the complete body. He says, law is passed by legislature in skeleton form. It's like body, human skeleton, and flesh and blood is given by judiciary. How judiciary gives flesh and blood? Life is given by judiciary by interpreting. Means same law, suppose law X, provision ABC, this provision A circumstance 1, the same provision A circumstance 2, same provision A, this is A, you perceive A, circumstance 3 will be interpreted differently. So here interpretation will be something else. Interpreting the same law in 2 or more different circumstances will be done differently. And that it happens a person is killing someone in self-defense. A person kills someone to rob him. So robbing's condition, trying to robbery done in a house and criminal kills someone. So conducting robbery, circumstances may be different. And the amount of punishment will vary with the person, under what circumstance that robbery was done and what led towards death or killing of a person. And a person who is killing someone for robbery and a person killing someone for self-defense, circumstances are too different, so punishment will be different. Even if law is defining these two circumstances or these two conditions, robbery killing, self-defense killing, but it can't define all different robbery related circumstances which led towards killing. This is done by judiciary. I can recall a very significant judgment given by court in 1955 in a Bela Banerjee case. Bela Banerjee case is a popular case, and West Bengal land reform related case it is. So West Bengal government had passed a law, and under that law it provided for some compensation to the zamindars, landlords. Bela Banerjee, belonging to zamindar family, she came to court that compensation is not reasonable. Huge land was taken by the government, but the compensation given is very less. Court knew that zamindari system, landlords amassed huge wealth, they exploited wealth, wasted in luxury, they did not do reforms on land, they did not care for the peasants or tenants. There was huge exploitation of the masses. So there is requirement of taking these laws from landlords and distributing it to the landless peasants. That we call as land reforms. Kerala, West Bengal, they were the pioneers in the land reform process. Then Supreme Court's verdict that time. Supreme Court has given a judgment at that time that a law cannot be challenged on the ground that compensation given to zamindars for land acquisition is not reasonable. Is you can't challenge a law on the grounds of compensation provided. On other grounds, law can be challenged, but on this ground, law cannot be challenged. That the compensation given to zamindars by state is not reasonable. That was judgment that time. And one issue came in Uttar Pradesh. Is a Bhatta Parsol is a place where movement by peasants started. That was Mulayam Singh Yadav's rule that time. So in Bhatta Parsol, Western UP, the peasants' land was taken by the government or allotted to the builders. And the compensation given to the peasants was less. Peasants sat on dharna. The national level movement started. Rahul Gandhi also went there. Even his UPA government was there at power. He went there. He was criticized for so many things. Matter went to Allahabad High Court, then came to Supreme Court. Allahabad High Court had given the judgment and Supreme Court upheld it later on. That a law which is not providing for adequate compensation to peasants for the land acquisition shall not be considered valid. The court one time said the land acquisition compensation is improper, law can't be challenged. Bela Banerjee case. Bhatta Parsol case, court said that a law which is not providing adequate compensation to landowners, it is valid, invalid, void. Several examples are there to prove this, that law, a particular provision of the law in different circumstances can be interpreted differently. And when this interpretation is done, some words are given to that interpretation becomes law. Okay. So you know that judiciary's decision, especially Supreme Court's decisions, have validity equals to law. So when they give this judgment itself becomes, the interpretation itself becomes law. And this interpretation is the most thrilling function of the judiciary. When judges are there, judges feel delighted, they feel thrilled when they give this type of judgment. So here, according to Justice P.N. Bhagwati, that law is passed by legislature in skeleton form, flesh and blood is given by judiciary by interpreting it, This is nothing but making of law. It's like lawmaking. Then how can we say judges do not make law? Then how can we say judges do not make law? And if judges can make law and they are taking the task of making law, then why we can say they are encroaching into the functions of legislature? And if by making law they are performing the task which they should perform, then how it is activism? So how can we claim activism exists? Therefore, activism is not a reality. In fact, the judges are doing the task which they are doing for years. Only we interpret the photographic view of justice. We interpret the photographic view that judges do not make law. Judges in fact make law. And that he explained. So, according to P.N. Bhagwati, what is truth? What is reality? Reality is the first point, is the first view. There is nothing called activism. Rest two views are there. Second views, I said activism is good. And why activism is good? Because with the help of activism, the rights of the citizens, especially vulnerable, downtrodden, poor, weak, can be protected. Legislature or executive excesses can be checked. Some constructive steps can be taken in the interest of society, citizens, as well as humanity. A right direction can be given to the state, to the governing bodies, in the interest of all. And that, to prove this how activism is good, we have concept of PIL. P.N. Bhagwati himself, who given birth to concept of PIL, he talks at length about its significance. But let's see views of most of the judges. Judges not only commented upon PIL as good, sorry, they also encouraged PIL. PIL was encouraged by them. Means a judge in one day of hearing 4, 5, 6 cases, there was a time when judges every day average 1 PIL a judge was hearing. Big number. That means PIL, public interest litigation, is good. So here we need to know activism is good. Activism is good. How activism is good? So to protect the rights of downtrodden, vulnerable. How it is good? When legislature, executive fails to perform, legislative, executive excesses are there, negativities in them, oppression by them, misuse of power by them, excesses are there. For progressivism, for progress, giving new direction to society, okay, to protect humanity, society, to bind or harmony in society, environment. For these reasons, activism is good. And the best example how activism has been proved to be good. If you have to give example of activism, so we have example like collegium, we have example basic feature doctrine, we have PIL as a concept, like that. You can pick some example. Okay. So judiciary intervening into functioning of the legislature, executive.